Welcome back. Until now, even if police suspected that you posed a risk to yourself or others, even though police were aware that you had guns in the house, there was little they could do. That changed after Parkland, after the new Marjorie Stoneman Douglas High School Public Safety Act. Now police are allowed to seize guns and ammunition from those suspected of posing a threat to themselves or others. If you want them back, you have to go to court and convince a judge. Anything and everything that deals with guns and gun control is a polarizing issue to the max. Taking guns away from those with serious mental issues, not so much. Still, there are questions that remain, and joining us for more are Anthony Schembri, who has too many titles, but remember the TV show The Commish? He was the inspiration. Jeff Young, this one is a little bit easier. He is known in Sarasota as the gun lawyer, and Dr. Eddie Renee is one of Sarasota's best psychologists. Gentlemen, thank you all for joining us tonight. As we speak, police agencies around the Sun Coast, across Florida, are trying to come up with policies to deal with the new state law, and I'm going to talk about Sarasota in a moment, but Jeff, you're the attorney here. What do police, the law is the law, but police departments have to come up with actually procedures, correct?
Correct. The law lays out the statute that says law enforcement now has this authority, and each department is going to have to come up with a way to set up procedures to enforce that authority. In other words, the easiest thing to point out is law enforcement are the ones who fill out this affidavit and send it to a judge asking for this temporary order. Is it just going to be the road deputy who fills it out? Is it going to have to go to a supervisor and get signed off on? Does it have to go up to a designated person who are going to review all these things before they submit them? These are the type of in-house things that the law enforcement have to come up with.
So the procedure in Sarasota could be different than the procedure in Manatee?
Absolutely.
Okay. Let me give you a statement and read a part of it that we got from the Sarasota Sheriff's Department today. It says, in part, the Sarasota County Sheriff's Office has a current but somewhat temporary policy in place to handle the RPO as warranted. We are currently communicating with other agencies as well as the court administration and the chief judge here locally to determine procedure and how best to implement the policy. Our office receives the daily legal updates regarding RPOs and issued throughout the state, and input and feedback from the legal community to determine the order's effectiveness and possible limitations in other communities. And it goes on to say that the colonel in charge of this is actually having a meeting on this tomorrow. But Commissioner, from what you read there, do law enforcement agencies have discretion in terms of the implementation of this new law?
Yes, and I think you'll see the civil rights people look for an abuse of discretion on the part of police officers who respond to these kinds of calls. Under what conditions? Was it a domestic violence situation? Did the wife or the husband have indicia of injuries, things of that sort, that would make the officer say, okay, if there are any guns in the house, I'm going to seize them.
Right, but I would imagine that if anybody takes issue of it, it would be after it really is implemented. Doctor, is this law a long time in terms of coming?
Well, you know, Alan, anytime we take weapons away from dangerous people, it's a good thing. My fear is that we're going to equate now violence with the mentally ill, when the mentally ill only constitute a small percentage of the violence in our society. And that's my worry, that people will misunderstand this law to mean that if you have a mental illness, you are dangerous.
But specifically, this law, correct me if I'm wrong, is designed to deal with those who are voicing, or there's evidence of being a threat to themselves or others, like the Parkland shooter.
Yes, as I said, anytime we take weapons away from dangerous people with mental illness, that's good. But a better solution would have been to create mental health treatment programs, to fund hospitals, and make access to mental health services more accessible rather than further stigmatizing the mentally ill.
I would point out, as I often do, that Florida ranks dead last in the entire country in terms of the spending on mental health issues. Obviously, we are just getting warmed up, and we'll have much more on the new red flag law right after we check First Alert Weather, so stay with us. Welcome back. We are talking about Florida's new red flag law, and joining us for more are Anthony Schembri, the former corrections commissioner of New York City, Jeff Young, known as the gun lawyer, and Dr. Eddie Renee, a Sarasota psychologist. And as we mentioned, departments are right now talking about how to implement this new law. There was one quote from a local police chief who said that the problem right now is that the legislation was constitutionally vague and overly broad. It all comes down to what the legislature means by a threat. Jeff, I'm going to give that to you again in terms of a threat to yourself or to someone else.
Yeah, of course. I mean, that's always the concern when you're dealing with new laws in general. Certainly as a Second Amendment advocate and a gun owner, we don't like those vague terms, as was pointed out by the commissioner, that there's too much officer discretion involved. So if they could all drive around with a licensed psychologist in their car and could do an evaluation on the guy right at the scene, that would be one thing. But when you're dealing with law enforcement officers who already are on heightened alert, who have their own stress, or may not have the great training or education, and all of a sudden they're confronted with this person, I'm just afraid it's going to be too easy for them to err on the side of caution and say, let's go ahead and try and take this guy's guns away.
All right, Doctor, let me ask you this question. I'll put up, kind of an example of something. Let's say someone is indicating that they may be suicidal. In terms of how far do you go back? Does it have to be within the last 24 hours or a week or 2 weeks or a month? Where do you go back to say, okay, that person is an imminent risk and should not be in possession of a firearm?
Well, the way we think about it, a person who is dangerous at the moment, they're dangerous today. They may not be dangerous tomorrow, and they may not have been dangerous yesterday. So the issue is, what is their mental status at the time that a crime is committed or just before the crime? And that we really don't have a lot of good data on. We know there are dangerous people. There are people who suffer from serious mental disorders that make their mental disorder makes them dangerous. There are a minority, a very small minority in the mental health community. But those people, it's hard to predict who's going to act. There's so many factors affect how a person acts.
So couldn't somebody be making some kind of statement or putting something up on their Facebook page maybe a couple of days ago or last week indicating that you should be concerned about their predisposition here, but when police come to their front door, they may be acting perfectly rationally?
That is absolutely true. We shouldn't take any threat not seriously. We should take every threat seriously. And we should check that person out. They should have a thorough psychological evaluation in order to get a clearance that they're safe.
But as Jeff just said, police don't travel around with psychologists.
That's the problem with the law, isn't it? That's the big problem. And in fact, many people who make threats never carry them out. In fact, the overwhelming majority of people who make threats never carry them out. A very small minority do. So if we are going to look at the internet and find everybody who makes a threat and investigate them, we'll be bogged down with work.
So Anthony, we keep on saying we want to keep guns away from people who pose a risk to themselves and to others. Beforehand, police, in terms of, there was very little that they could do. Now they have discretion to do more, and the question is whether they should have that discretion at all.
You know, if I were to put all of the theories of criminology together, it would boil down to this. The formula for crime is opportunity plus desire equals a crime. What we're trying to do here, and what the legislature is trying to do here, is to eliminate an opportunity. So I don't like the abuse of discretion, but let it work out and see what it does. And of course, have research at the end so we could see and evaluate how this thing is working.
You know, Jeff, you indicated that you're supportive of the goal here. Does what Anthony say sound reasonable, that we have to see how this is going
Everything
to be?
I say is reasonable.
Really? Let me look at my notes here. No, I mean,
Well, I would agree. Yes, as I've said before when we've talked on this subject, the concept of the law doesn't bother me. I agree that, just like everybody else, we don't want firearms in the hands of mentally ill people who are current danger and that are going to cause problems, not just mentally ill people, but dangerous people. So the concept of law is good. And when you have clear-cut cases, nobody's going to complain. Somebody who's clearly a danger to themselves or others, they're the ones that make the newspaper, it's not a big deal. What I always concern myself are the gray area cases where it's not so clear-cut, and I believe that law enforcement, for liability reasons or whatever, are always going to err on taking the firearms away because they don't want to be the one who doesn't, and then a shooting happens.
Because those gray cases, those non-clear-cut cases, are the cases that too often turn out to be something significant. I don't want to change the subject completely here, but we're all aware of what happened the last couple of days in the Memphis area at the Waffle House. Here is a young man who tried to jump the fence at the White House to talk to President Trump. The Secret Service and the FBI took his guns away and gave them to his father, who gave them right back to him. We have a soundbite to play.
The police department has received information that the guns were returned by Tazewell County authorities to Ryan King's father, who has now acknowledged giving them back to his son.
Gave those guns back to a son who was, absolutely doing things that one would question his mental capacity. We don't know what was going on in that father's mind, but Jeff, I don't know if legally he did something wrong there, or I can't imagine what he was thinking. But how does the law handle this?
Sure, I don't know under that particular law what his legality is. I know under the new Florida law that you are permitted to turn your firearms to a third-party person, a family member, etc. And if they then return those firearms to the person without court-ordered permission, they themselves could be subject to criminal charges. But I think this just denotes what we as gun owners always say. You can pass as many laws as you want, but when there's a will, there's a way. If you have somebody that wants to do harm and wants to do violence, they'll either get a family member to give them the gun, or they'll steal the gun, or they'll use a truck like we saw today in Canada. I mean, you can pass all the laws that you want, and you may catch some of the people, but I don't believe that any law is ever going to stop these issues.
And that leads the trained psychologist to say what?
Well, again, we're stigmatizing the mentally ill. Certainly in a law like this, we should accompany it with also another law that says that if your guns are taken away because you have a mental disorder, that you must also receive treatment. And in that treatment should address violence and dangerousness. And that's what's missing.
But obviously, I mean, that goes to a civil rights issue. You cannot force somebody to get treatment for a medical condition.
We do that all the time.
Okay.
We require people to have mental health services in family law. We require people to have mental health services in criminal law. We require people to see people for substance abuse, to enter treatment programs all the time.
Anthony,
It's actually true. Even in domestic violence injunction cases, the court has the authority to order people to attend things such as anger management classes, get a mental health evaluation in order to have the injunction lifted from them. So that is something that you could explore in this new law as well.
You know, Anthony, you have served in senior law enforcement capacities both here in the state of Florida and in the great state of New York here. When new laws go into effect, like what we're talking about here, does it take some time to really kind of figure out how it works in any state and what needs to be then redone or fixed in some sort of way?
Well, these go right to the police officer's locker room. This is where we see it work or it doesn't work. And what we're seeing in the 50 major cities in the country is we're seeing the Ferguson effect, where officers are not performing some of the duties they're supposed to be doing for fear of lawsuits or getting in trouble. Search and stop and frisk laws are not being used as they once did in New York too. So we're seeing that I think you're going to see some officers afraid to use their discretion in this law.
On the other hand, do you think that this new law does give police officers discretion, which they did not have before? Sometimes you do see a situation that you could see the danger coming, but before the police officers were handcuffed from really doing anything about it at all.
Well, in my career, I've seen the abuse of discretion. I'm always, without policies and procedures, I have to see how they're going to use their discretion in enforcing something like this.
Doctor, correct me if I'm wrong, and we're running out of time here, but do you see any merit to this new law here in terms of the mental health capacity?
Absolutely. We needed to move towards a society that at least offered some control over some people, who particularly dangerous people, their access to guns. And this gives us at least the beginning first step. It's not the end, it's the beginning first step.
Okay, we have to take a quick break, and we'll be back for final thoughts in a moment, so stay with us. And our guests join us right now for final thoughts. And Jeff, I'm going to start with you. So how is this going to work out? Police departments, law enforcement agencies are doing what they're doing. They're going to start implementing it. And then is it really up to attorneys like you, if you believe that there is an abuse, to somehow challenge it in court?
Yeah, I mean, the good thing in this particular case, and we're all not trying to beat up on law enforcement officers, but they're supposed to submit the paperwork to a judge. So the judge is the one who's making the ultimate decision of whether to give the temporary injunction and make it permanent or not. It's not just the discretion of law enforcement. So the hope would be that the judicial branch would be the ones who would be the check on any abuse of discretion that we have. But I would agree that this is a brand new law. When you have the clear-cut areas, it's fine, but when you get into those gray areas, we're going to have to see how it shakes out. We're going to have to see how many of these are granted, what they're based them on, if law enforcement is being truthful in their affidavits, are we coming up with any abuses, and we are going to have to kind of wait and see how it shakes out.
Anthony, how long does it usually take for police departments to train officers about a new state law that basically changes procedures significantly?
Well, it's usually done in lineup procedures. When the officers turn out, they might give them a lecture. They might send them some material that they have to read. Some even give a test so they fully understand it, or bring in a department attorney and go over it. We need to have a wait-and-see attitude about this. The part that I don't see that concerns me is the research aspect. A year from now, are we doing it more to black defendants than we're doing it to white defendants? Are we doing it more to women and not to men? We need to have a research aspect to see where we're at. That's the part that's missing here.
And Doctor, you said that another major problem is someone could be a threat today and not tomorrow. So how does a law handle something like that?
Well, this law doesn't. So if you say something that makes you sound dangerous, your guns are removed. But someone with a mental disorder may fluctuate. That is, they may be dangerous today, not dangerous tomorrow, and dangerous again in some future date. So no law is going to handle that. Therefore, the way to do it, really, the best way to reduce a threat of violence from a mentally ill is to provide them with treatment. That means funding mental health services, training people how to evaluate and treat the dangerously ill. Those kinds of things that we don't seem to be interested in.
All right. Unfortunately, we have to leave it there for now. FYI, you can watch past discussions on demand. They're available on Apple TV, Amazon Fire, and Roku. We want to thank our guests for being here tonight. Anthony Schembri, the former Corrections Commissioner of New York. Jeff Young, known as the gun lawyer, and Dr. Eddie Renier, a Sarasota psychologist.